What's up, citizens? Welcome back to the Leo Dotson Show. Today is our the third part of our three-part series on U.S. healthcare. If you didn't catch it in the first section, we basically looked at a backdrop of the industry as a whole. We found that our costs are skyrocketing. They're the largest, most expensive costs of any healthcare system of any nation on earth. We have plummeted from the top best healthcare quality to the 37th and dropping. We also, in Section 2, we looked at Obamacare, ACA, Affordable Care Act, objectively at the pros and the cons, and we found that there were some features of Obamacare that actually were helpful and some that maybe we didn't like, but the main issue we were looking at is the mandate. Now, bringing us to the third section of our healthcare analyses and series is the constitutionality that's being judged as we speak by the Supreme Court. They heard hearings 3 days worth, which is somewhat unprecedented, certainly lately, of hearings on Obamacare, ACA, and they will be ruling on that in June of 2012. Part of that is really the mandate. There were 3 different days of hearing. Each of those days in the Supreme Court heard arguments both pro and against the government's plan of Obamacare, ACA, and they looked at 3 different things. The first thing to look at on day 1 was, could the Supreme Court even rule on it immediately? Basically what that meant was, is it a mandate, which they could rule immediately, or is it a tax? Meaning that if we're making people buy health care, which the Obamacare does, the mandate, can that be considered a tax? Well, it was argued that if it were a tax, there is a law in place from 1867 called the Anti-Injunction Act, which states that no Supreme Court can hear any case against a tax until after that tax has been enacted. The reason for that is twofold. Number one is they want to see how the tax plays out and what repercussions it might cause before they hear hearings on that. And then even more so from a functionality standpoint, if they didn't put that in, have an anti-injunction clause, then every time there was a new tax, people would simply sue or create a court case around it and tie the case up in court, which would essentially limit Congress's ability to tax and have any money to pay for defense or roads or bridges or schools or anything else. So in the first day, they made a determination that yes, it was a mandate, that it's not a tax per se, and thus they can hear it immediately. Because otherwise, the tax doesn't fully go in, or the mandate doesn't fully go in until 2014, which means the tax or penalty that you would pay for not having health insurance wouldn't hit until that following tax year, which would be April of 2015, which would clearly delay about 3 years the Supreme Court's ability to even hear the case. So the second day revolved around the mandate, and what it really does is looked at, the Obamacare mandate forces every American, with very few exceptions, to buy health insurance in the free market, and that's somewhat unprecedented, although the attorneys for the government argued that there was some precedent. What they used as precedent was in the U.S. Constitution, Article 1, Section 8, which is the Interstate Commerce Clause. What that actually says is Congress shall have the power to, among other things, regulate commerce with foreign nations and among several states. And in previous cases that are somewhat like this, there was a case in Alabama where there was discrimination of a person who owned a restaurant. He didn't want non-whites visiting his restaurant. And the Supreme Court determined that if you have a private club, of course you can select which members you allow to join your private club. But if you have a restaurant or any other type of business open to the public, you can't pick and choose based on race. Because these people were operating in an interstate commerce that the Congress actually had right to rule on that, and the Supreme Court upheld that. Another one was a case of wheat, where someone was growing wheat, and that obviously contributed to the supply of wheat, which would affect the markets, and since that was an interstate commerce regulation, they were simply doing their job, Congress was, in terms of regulating the supply in the wheat markets, which would dramatically affect prices negatively for consumers. And then the other one was someone in California had been growing medical marijuana, which was legal, for their own personal use, but that could also be regulated because that's an industry that the government is already regulating, and they could tell you whether or not you could grow that. I think that was a little more invasive in terms of civil liberties, in terms of the Bill of Rights, but certainly at least we could say in all of those cases that people were actively participating in business. They were doing something. They were making a product or service in an industry which was interstate commerce, which by the Constitution, Congress does have the right to regulate. In this case, since it's health insurance, people have brought up, well, you have to have auto insurance. It's nothing new, and I don't think that's a very good argument at all, because first of all, let's look at auto insurance. Number one, you do not have to have auto insurance. You don't have to have a car. You don't have to drive. You can bike. You can do whatever. In fact, a lot of people in Manhattan consider it a liability to own a car and use the mass transit systems, and other areas of the country have that as well. But even if you do own a car, you don't have to have auto insurance. What usually is required by law is that you have liability insurance. It doesn't cover damages for your car. You're not insuring your car. You're simply making sure that if you cause damage, that you're insured to cover someone else. So it's a liability issue, not necessarily an insurance issue. And also, and maybe most importantly from a constitutionality standpoint, is these laws in auto insurance are typically enacted by the state, which if they in their constitution they have the right to do so. We're not talking about a federal government coming into the interstate commerce clause and regulating citizens of various states. It's a different ball of wax. So the argument with the government on this is that since almost all of us, some would argue all of us, will use health care in our life, we're already in that system. But I think there's an assumption there that's really not true in the restaurant, wheat, or weed industries, where people are already engaged in it. The government essentially is assuming that you will need health insurance, whether you're using it today or not. And I think that's a little more of a leap of faith than people who are already engaged in a particular industry. Also, I believe if you look at what if someone never uses health care, you're forcing people to buy that. Now, so if I had to make it, I mean, there's good arguments, pro and con, but if I were on the Supreme Court and I had to make a judgment, I would rule the mandate portion of Obamacare unconstitutional, because I believe it takes a new step in forcing people to do something in a free market that I don't believe the framers of our Constitution had in mind. Now, the third day of the Supreme Court hearings heard on the argument for severability, meaning that if the mandate is found to be unconstitutional, which I would side with that, can the other areas of Obamacare be upheld? In other words, if we strike down the mandate, does that eliminate everything and then all of Obamacare? And once again, remember, the Leo Dotson show is nonpartisan, and it's very easy for this to be a partisan issue. If you're a Republican, then you hate 100% of it, and everything in Obamacare is wrong, and you want to completely repeal and do away with all of it. What that puts us back to the immense expenses and problems we had before. And if you're a Democrat, then of course everything about Obamacare is wonderful, and neither one of those scenarios is true, and that's just not the way the world works. And I think that they will rule that there is severability, that if they rule that the mandate is unconstitutional, that certain aspects of the health care bill that have maybe improved health care could be kept in, but just find new ways to finance it. There's lots of ways to do it. They could do it with a tax, which would be constitutional. I mean, we're already paying Medicare tax. This would just be an additional tax for health care, which if you're already in the health care market, if you're already paying for health care insurance, it wouldn't cost you a penny at all. It would only be a tax if you're not paying any type of health insurance at all, as a way to have people to come and share the cost with the rest of us who are paying for health care, which would reduce the cost for us individually, but without making it a mandate and forcing people to do certain things. So that's a quick synopsis of the Supreme Court constitutionality of Obamacare. I hope this helped from an informative standpoint. Once again, thank you very much for watching the Leo Dotson Show. You may now return to your regularly scheduled television propaganda and news media mind control, already in progress.